Good morning, and thank you for your attendance and your interest. Rob Bonta, California Attorney General, here to share with you an announcement from our office. We are announcing an action to protect California's privacy, our safety, their trust in law enforcement, all of which are non-negotiable for us and have been put at risk. I'm here to ensure that the state law is followed and that residents across California have confidence in the people and institutions who are entrusted with their sensitive personal information. One of the most important protections secured in recent years is a law known as Senate Bill 34. This law was passed by the California legislature back in 2015, and its goal and role is to ensure that data collected through automated license plate readers, ALPR systems, is protected and remains subject to California oversight. The law makes it clear that this data can't be shared with federal or out-of-state law enforcement agencies. Unfortunately, despite clear guidance from my office and multiple warnings, the city of El Cajon and its police department have refused to comply with this law. Today, we're taking the next step to protect Californians. We are asking the court to declare El Cajon's practices unlawful and to order the city and its police department to stop sharing this data unlawfully, which they are doing now. For those who aren't familiar, ALPR systems are computer-controlled cameras that capture images of license plates along with the time and date and location of each encounter. On the surface, this may seem like routine law enforcement technology. It's definitely very helpful law enforcement technology when used appropriately. But the reality is far more serious. ALPR systems can collect and store location information that reveals where people live, where they work, where they worship, where they seek medical care, shop, travel, and spend time with family and friends. This is data that can reveal extremely sensitive aspects of an individual's private life and of their routines. Because of that, California law is very clear. California serves as a regulatory steward of its ALPR data, ensuring its use aligns with constitutional privacy protections and community trust. It can't be shared with federal or out-of-state agencies. Let me just be clear about that. The ALPR data collected in California cannot be shared with federal or out-of-state agencies. And when it is shared, if it is shared with out-of-state agencies or federal agencies, and this is the rationale and thinking behind the law, there's no guarantee with respect to how it will be used, no oversight to protect the rights of our residents. We lose control of that data when it's shared with an out-of-state agency or with the federal government. Unregulated access to this data, it risks violating civil liberties and diminishes public trust. When information leaves California, we no longer have a say over whether it will be misused, whether that's for immigration enforcement, surveillance of protesters, tracking individuals traveling here for reproductive care or gender-affirming care, and other purposes that could fringe on constitutional rights. Despite repeated guidance, and I want to emphasize repeated here, we've had multiple conversations with El Cajon, and they are stubbornly refusing to comply with the law. El Cajon continues to share ALPR data with out-of-state agencies in at least 23 states, including Alabama, Arizona, Florida, Illinois, Texas, Virginia, Washington, and Wisconsin, among others, and it is unlawful. Our office reached out directly to the El Cajon police chief and city attorney to provide them with guidance and model policies and let them know their sharing of information with out-of-state agencies did not comply with state law. We were hoping to resolve this with collaboration and conversation, guidance, and partnership, as we have with every other agency that we had concerns about. We were able to work it out. There was collaboration. There was willingness to follow the law. When a law enforcement agency deliberately and stubbornly refuses to follow the law, that is a problem. and thus we are here because of El Cajon's refusal to follow the law. We're hauling them into court to get them in compliance. We also issued statewide law enforcement bulletins in October of 2023, making clear that California law enforcement agencies that collect or use ALPR data can't share that information with federal and out-of-state agencies under SB 34. So there were multiple communications directly, statewide. They could read the law themselves, where El Cajon was put on notice of their unlawful law-breaking activity. Yet El Cajon has willfully disregarded these warnings and continued its illegal practices, putting the safety and privacy of its residents and those traveling to El Cajon at risk. That's why today we filed a lawsuit in California Superior Court to bring clarity, to bring accountability, and to bring compliance with the law. Protecting ALPR data is about more than just following the law. Compliance is the floor, not the ceiling. It's about protecting public trust in law enforcement. Communities won't feel safe reporting crimes, cooperating with police, or trusting that their personal information is being handled responsibly if their private information can be freely shared with agencies beyond the reach of California law. Today's action is especially as important as we've got a federal administration that's targeting immigrant communities and other vulnerable populations, targeting access to reproductive health care, targeting patients seeking reproductive health care, and providers providing reproductive health care, targeting patients seeking gender-affirming care, and providers providing gender-affirming care. We can't allow state or local law enforcement to become tools for enforcement practices that violate Californians' rights. Take, for example, earlier this year, a Texas sergeant investigated a woman seeking an abortion and utilized ALPR data to search for her. This search included cameras in states where abortion is fully legal. Just one example of how this ALPR data can be used in harmful ways. The consequences for these violations of privacy are too severe to allow the misuse of this data to fly under our radar. My office is committed to holding everyone accountable, including public agencies, including law enforcement agencies. If a law is being violated, we're going to step in. We'll use every legal tool at our disposal to protect Californians' privacy. Today's action is one example of that commitment. Let me be clear that we will continue to protect the privacy, safety, and constitutional rights of all Californians. The city of El Cajon is not above the law, and state law must be enforced and will be enforced. Our petition asks the court to affirm that ALPR data can't leave California without oversight and to order the city to comply immediately. This is about more than one city. It's about ensuring that every Californian can trust their personal information is handled responsibly, that the law is being followed and complied with. Our office will continue to monitor compliance statewide, work with local law enforcement agencies to implement best practices, and take legal action when necessary. In California, we're making it clear. Privacy matters. Public trust matters. Safety matters. I'd like to take a moment to acknowledge and thank the dedicated team in my office who've been leading this work. They don't do it for the recognition, but I want to recognize them. Amy Hamoy, Curtis Brown, Michael Cohen, Nancy Beninati, Damon Brown, and Daniel O'Bannon, an outstanding team who got us to where we are today. Thank you, and now I'm happy to take any questions that you might have.